Well, good afternoon, everybody. Talking Dispute Series. My name is Robert McDougall. I'm a senior fellow at ICTSD, and I'm going to moderate today's session. As you may know, the Talking Dispute Series is co-organized by ICTSD and WTI advisors. It's meant to promote discussion and exchange on specific international trade disputes among a variety of experts and a broader audience. For that, we invite experts familiar with the issues to make presentations here and then promote a discussion among themselves and among participants yourselves when we get to that session. This evening, we're going to talk about the arbitration panel report in the Guatemala-U.S. labor enforcement dispute brought by the United States under the CAFTA-DR free trade agreement. It's a very interesting dispute for a variety of reasons. It's one of the very few panel reports that's come out of an FTA dispute settlement mechanism, so it'll be interesting to hear about some of the novel practical, interpretive, and jurisprudential challenges and developments in that context. As far as I know, it's also the only adjudicator report that's dealing with labor obligations that are in a trade agreement. So the report may break some ground for similar types of disputes, and will certainly open a discussion about questions of the interface between trade and labor obligations. And more generally, it comes at a time when governments everywhere are focusing on trying to make trade more inclusive. And one of the ways in which they're talking about doing this is building better linkages between trade and other policy areas such as labor, environment, and other social policy issues. And it'll also be interesting to hear whether or not these linkages can be made more effective. And at least in this case, it'll focus discussion on how labor policies affect trade. We have, for this discussion, assembled an all-star panel to present and discuss the issues. With their guidance and with your participation, we hope to have this a wide-ranging discussion of the issues in this precedent-setting dispute. Before we start, though, I just want to make a couple of housekeeping announcements. First, we'd like to thank the mission of the United Kingdom to the WTO for its support for today's event. And to bring this discussion to a wider audience outside of Geneva, the event is being live streamed. In fact, one of our panelists is also going to be streamed in. And we'll be receiving, hopefully, comments and questions from those who are viewing it online. Equally, comments and questions from people following it on Twitter to anybody who's actually live streaming it there. And third, in front of you there are feedback forms, and I would encourage you before you leave the session to fill those out. It really does help the organizers improve these kinds of events in the future. And lastly, following the discussion, we'd like to invite you to join us all to continue the discussion in a reception that will take place immediately after the session in the gallery, which I understand is the room that's above the cafeteria, which is that way, I think. But afterward, just follow the stream of people that will be going towards the gallery. So, for our four distinguished speakers, three of them here in the room and one of them soon to be online, we hope. He's online now? Okay. It would take too long for me to introduce them all properly, so I'm just going to refer you to the documents in front of you that have their more detailed biographies, and I'm just going to make a more cursory introduction right now, and I'll introduce them in the order in which they'll be speaking. Our first speaker and the main presenter of the report is, to my right, Colette van der Ven. Colette's in the Geneva office of the law firm of Sidley Austin, where she's the e-commerce coordinator of its Emerging Enterprises Pro Bono program. And she also engages in independent research and writing and conference appearances on trade law, industrial policy, and development. Colette's going to present for us today the opening assessment and the significance of the findings. Our second speaker to my left will be Professor Joost Pauwelen. He's Professor of International Law at the Graduate Institute of International and Development Studies here in Geneva. He's a visiting professor at Georgetown Law Center, and he's the head of the TradeLab.org network of legal clinics. He's also the author of one of the leading casebooks in international trade law, and is co-editor-in-chief of the Journal of International Economic Law. Joost is going to comment on the dispute from the perspective of international trade law and investment law. Our third speaker to my far right is Pablo Lazo Grandi. Pablo recently chaired the revision of the ILO Tripartite Declaration on MNEs and is a member of the ILO's Advisory Committee on Workers' Rights in Globalized Economies. Pablo has been an advisor and expert on labor and civil society issues to the Chilean Foreign Ministry, to numerous intergovernmental, governmental, and non-governmental agencies and organizations throughout the Americas and Asia. And Pablo is going to comment on the relationship between labor standards and free trade agreements. And finally, Doug Palmer, who is going to be joining us from Washington by a video stream. Doug is one of the most experienced trade reporters in Washington. He was in Seattle in 1999 and has continued to cover WTO negotiations since then, and along with trade negotiations with more than a dozen countries with the United States. Doug currently keeps tabs on trade frictions with China and mega-regional trade negotiations, and Doug's going to provide some insights on FTA negotiations and renegotiations in the context of U.S. politics. So, with those brief introductions, I'm going to turn immediately to Colette for the opening presentation.
Thank you so much, Robert, for the introduction. Thank you to WTI advisors and ICTSD for organizing this panel and having us here for the WTO. So it's my honor to present to you this, as Robert said, which is the first ever dispute that has litigated a labor provision. So it's extremely exciting dispute. There's a lot to talk about. I've had to select a few salient elements of this dispute as to not sit here for another 2 hours. So forgive me for cutting perhaps your favorite part of this report, but I'm sure there's plenty of discussion to come back to any of those later on. So to set the stage, as most of you may be more familiar with WTO disputes, this is a dispute that arose under the CAFTA-DR, and that is a free trade agreement between the United States, Central America, and the Dominican Republic. That was adopted in 2006, and the Dominican Republic joined 2007, Costa Rica in 2009. And this trade agreement is also known as a third generation agreement by virtue of the role of the labor chapter in the agreement. So, for example, unlike NAFTA, where you had a chapter on labor that was separate from the actual trade chapter, here it is within the provisions. It's chapter 16. And you also have one of the trade provisions that is enforceable, but it's, one of the labor provisions, but it's only one. So it's only the one that deals with the obligation not to fail to effectively enforce labor laws, the one that's at issue in this dispute. The other labor provisions are not enforceable under dispute settlement. There's also another interesting feature under dispute settlements, which is that by and large, labor provisions are litigated along similar ways as commercial provisions under CAFTA-DR. However, labor provisions, there is a cap on monetary penalties of 15 million, and there is a few other minor differences between the two dispute settlements tracks. So that's just for you as kind of broad overview to keep in mind as we delve into the details of this dispute. So how did we get here? I'm sure those of you who've read about this have heard and seen provisions and outrage about this taking 9 years. And why did it take 9 years to finally get a report published on this issue? So a little bit of background, I think, in terms of the timeline is also warranted. The U.S. first raised claims with respect to alleged Guatemala labor law violations in 2008, but it didn't go directly to either consultations or dispute settlement because under the labor chapter, you're mandated essentially first to go and resolve issues through cooperative manners, so non-dispute like. So a number of U.S. labor unions and Guatemalan labor unions filed a complaint in the Office of Trade and Labor Affairs. A year later, a report was issued with recommendations vis-a-vis these allegations of labor law violations. And the report also issued a recommendation not at that time to pursue further dispute settlements with respect to these issues. But later on, the U.S. was dissatisfied with how Guatemala enforced some of these recommendations and nevertheless went on to file first consultations, and then when those were unfruitful, a panel request in August 2011. So you see on the slide where the dividing line is August 2011 is essentially the key date in this dispute. That's when the U.S. filed a request for panel establishment. And then you see in July 2017, which is 6 years later roughly, is the publication of the dispute. Now, in between, you see those two crosses, because what happened is that at multiple times in the proceedings, Guatemala and U.S. suspended, jointly the proceedings, because again they were trying to resolve this in a mutually satisfactory manner outside of dispute settlements. But that didn't work. So you see really here a desire from both sides to get this resolved outside dispute settlement. In November 2015, there was another month of suspension because one of the panelists resigned, and instead they got Ricardo Ramirez to replace him, one of the appellate body members. So that was also some internal issues that took place there. So also one thing to notice is that there's no appeal under the rules of the CAFTA-DR. So this is essentially it. We're at the panel stage. We've got a report, and that's what we've got to deal with. The procedural rulings. There are two elements in this report that Guatemala brought up during the initial couple of months that this dispute was going on. One was they considered that the U.S. request for panel establishment was not sufficiently precise under the relevant rules in the dispute settlement chapter, and so they requested a preliminary ruling thereof. And the panel felt inclined to see whether, according to the rules, they were able to actually have a bifurcated proceeding, essentially, with a preliminary hearing as well as a normal proceeding. And they found that, in fact, the rules required that they resolved any preliminary issue within the normal procedures. So there was no bifurcated proceeding. Everything was resolved just by the normal timeline. Then secondly, Guatemala also requested, after receiving the U.S.'s first written submission, they requested a request for extension to file their own first written submission, and they requested the panel to require that the U.S. submit unredacted versions of the evidence. So what the U.S. had done is essentially attach hundreds of declarations that were redacted. And Guatemala said, we need time to figure out what happened there, to locate those files and to respond accordingly. Our due process is violated by us not having the ability to do so. And the panel said that at that point in the proceedings, it was premature to request the U.S. to provide any of that information. And so they decided to deal with this information issue throughout the proceedings. So the two measures at issue that the U.S. raised are one, failure to secure compliance with court orders requiring employers to reinstate and compensate workers wrongfully dismissed and pay fines for retaliatory action. And two, failure to properly conduct investigations under the Guatemala Labor Code and failure to impose requisite penalties. And you see there is another measure that the U.S. notified, the third one, and they raised that in their first into submission, and that is a failure to register unions and institute conciliation processes within the time required by law. Now, the panel found that measure was not properly in front of it because there was no corresponding measure in the U.S. panel request. So that one, they considered it outside the scope. With respect to the first two, once they dealt with this issue that Guatemala raised regarding precision, the panel considered them to be sufficiently precise in the U.S. panel request and thus considered that they were properly in front of it. So the provision at issue, there's only one, which should make things a little bit easier, is Article 16.21a of CAFTA-DR, which is a party shall not fail to effectively enforce its labor laws through a sustained or recurring course of action or inaction in a manner affecting trade between the parties after the date of entry into force of this agreement. So you see that there's multiple different clauses in this provision, and we'll go through each of those as we go through the different measures. So turning to the first claim of the U.S., failure to ensure compliance with court orders requiring employers to reinstate and compensate workers. This claim is essentially what the bulk of the report is about, so I'm also going to spend more time speaking about this one than the second claim. So here, the first prong that the U.S. litigated was not that Guatemala failed to effectively enforce labor laws. And as you can see, it's a negative obligation. And there wasn't a lot of dispute about how to interpret this. Essentially, the panel said you look at results, you look at whether the government is ensuring compliance when they have notified violations. And what the problem here was, so the way that the U.S. set this out was, first they said the labor laws at issue are a number of provisions in the Guatemala Labor Code. So you can see it in the first book. And those all relate to the right to associate negotiation, the right for collective bargaining, typical rights that are also mentioned specifically in Chapter 16.8 of the labor chapter as labor rights. So they had that evidence. Then they submitted evidence of 8 different companies and of workers that had been wrongfully dismissed for engaging in labor union activities, and of court orders that considered that they should be reinstated. So that was essentially the bulk of the evidence, with a few other declarations and a few other reports. And so for each of those companies, as you can see, there were 4 shipping companies, 3 garment manufacturers, a rubber company. They had redacted declaration after redacted declaration of instances of wrongful dismissal. And you can also see the first line behind all the company names. Those are the number of workers with respect to whom the U.S. filed evidence of wrongful dismissal. And the second line are the number of workers for which the panel found indeed the U.S. had made a prima facie case. So that's roughly a third of all the evidence they submitted. And you may wonder, well, how did the court or the panel decide on whether or not the U.S. did or didn't prove its claim vis-a-vis those specific declarations? And that's also the bulk of what happened in the report, for those of you that have gone through it. And I won't go into the details, but essentially here I think we come to a very important part in the panel report, because this is what the panel really struggled with. And so they even felt compelled to note it in the report, saying at 2 different places, the panel feels compelled to note the difficulty of the task in view of the parameters set by the rules. And with the rules, they refer to the model rules of procedure that are also part of the DR CAFTA in a separate document. And those are silent with respect to rules of evidence or witness cross-examination or any of those other guidelines you would typically find in a domestic court. And so the panel really had to figure out what to do with this, thousands of pages of redacted witness declarations. And so the system that they devised was essentially weighing the probative value of the redacted evidence. And they looked at the presence of factors of reliability. And that included the verifiability or corroboration of independent sources, reliance on reported information of the declarant versus information or events he or she had herself witnessed, proof of spontaneity versus suggested. So for example, if there were 4 different declarations with similar or verbatim paragraphs, then it's likely that somebody else drafted those for the people that made them. Specificity in the evidence, whether they name inspectors, whether they name places or dates or times. So that's essentially the mixture of things they looked at. But what's interesting to note, I think, is that they considered it very valuable to have those declarations, yet the declaration itself wasn't sufficient. So it always required another document to corroborate it, for it to establish a prima facie case of violation. So going to the third prong, essentially, of this test. So you see I skip one, and we'll get back to that one later. So the third prong is that a failure to effectively enforce labor laws needs to be in a manner affecting trade between the parties. And that is really an interpretive issue that was the crux of the matter here. And so the U.S. essentially adopted a very broad approach, and they said, well, as long as if you alter conditions of competition, that will have an effect on trade. You don't need to really show effect of trade on trade. Whereas Guatemala said, no, you need to show that prices are changing or that flows of goods and services are modified. So very extreme positions on the interpretation of this, unsurprisingly so, given the positions of the parties. And the panel purportedly adopted a middle-of-the-road approach, where they said, in a matter affecting trade means an action must confer a competitive advantage on an employer or employers engaged in trade between the parties. And they adopted a 3-prong approach to get there, essentially, when dealing with the evidence. 1, whether the enterprise is engaged in trade with CAFTA-DR members. 2, the effects of failure of labor laws on the enterprise. And 3, any effects on competitive advantage on those enterprises. Applying this test to the case at hand, so they split up the companies by their nature. So 4 shipping companies, 3 garment manufacturers. And the reason they did that was because the shipping companies, they considered for any effect on trade to occur, they had to be passed on to the exporters to whom the shipping companies provided services. Because those are just the dock workers, the people that are in the port, essentially. And they found no evidence of cost savings on Guatemalan exporters, made reference to the U.S. having failed to provide any evidence of costs or prices at all. And they also found no evidence affecting conditions of competition. And that was because the port, the Quetzal port where these workers, the alleged violations took place, was administered by a quasi-governmental agency, which contracted out the services. So essentially the court said, well, any advantage, allegedly gained because of these labor law violations wouldn't be passed on to the exporter. It would be passed on in terms of profit. So there is no effect here. With the garment manufacturers, they looked predominantly at the actual effect of labor law violations on cost within a firm, and they found for one company that the U.S. had proven that that there were competitive advantages as a result of labor law violations, and that was for Avandia, which is a garment company. And the reason they did was because there were 9 union leaders that were dismissed after they requested collective bargaining in this firm, and the panel essentially said that the dismissal of the entire leadership of the union in that firm essentially means that all the rights of the employers in that firm are dismissed, and that creates a cost advantage that can be inferred, even though there was no direct evidence. So there they found that there was an effect on trade. Turning to the second prong, which we're mixing it around a little bit, because the second prong that you have to demonstrate for a violation of Article 16.2.1a is a sustained or recurring course of action or inaction, and in a manner affecting trade. And this slide combines them, because what the panel found was that for that one company, Avandia, yes, it did occur in a manner affecting trade. For the 74 instances, the violations that we saw earlier, those are recurring course of action or inaction. Yet those 74 minus Avandia do not affect trade. So essentially what the panel said is these are cumulative obligations, and they couldn't square this in any way where the US met both or the 3 prongs of this test. So you either had Avandia affecting trade but not sustained a recurring course of action, or 74 violations but sustained a recurring course of action not affecting trade. So that's why the US failed on their first claim, essentially. Turning to the second claim, this is about the failure to conduct proper inspections and failure to impose penalties. So this deals essentially with each time an inspector is required to go and inspect labor conditions after a complaint, or when the inspector has made a report that violations are taking place, they should impose certain penalties on the employers. So we're not spending too much time on this because it's quite similar to some of the other claims. So the U.S. had claims for coffee farms, for a garment manufacturer, for 2 garment manufacturers, and again the bulk of the evidence here that they presented to argue that Guatemala had failed to effectively enforce labor laws were redacted witness declarations. But unlike the evidence that was presented for the first claim, here they did not have the court reinstatements to essentially verify or to corroborate some of this information. So here you had a number of mostly joint witness statements about events that took place, at specific points in time, but they were often vague, and the panel didn't consider that sufficient to find that that Guatemala's inspections were such that they failed to effectively enforce labor laws. However, there is one exception, and that is in Fribo, a garment manufacturer, where there was a report by a labor inspector that essentially concluded that the conditions were so bad that action had to be taken. And that action wasn't taken. So on the third prong, on the third situation here, the panel said, well, we can therefore infer that they failed to impose the penalties as they should have. Hence, there is a failure to effectively enforce the labor laws. But this was only one instance, so they didn't have to go to whether, this wasn't an action that was sustaining or reoccurring, and thus this is where the claim failed. So the U.S. also did not prevail on the second claim. Briefly, a few preliminary observations. Reading this case, and as a WTO litigator, I thought it was very interesting, and I kept thinking, why is it so different from typical cases we read in the WTO, and what is it that we're dealing here with, thousands of pages of redacted evidence as the bulk? And part of that stems from the nature of the obligation, right? It's failure to enforce a domestic labor law. So typically in the WTO, you don't deal with those types of obligations. You deal with measures and the discriminatory impact of one measure on another country. So it's, and I'm generalizing, of course, there may be one or two instances where there are similarities. So I think the nature of the claim creates a very different scenario here, and also warrants a different bulk of evidence. And so having seen how this case plays out, it also tests the boundaries of litigating without having clear rules of evidence. And in the WTO, typically, most cases we get away with it. There has been a norm that has developed. But when you're dealing with thousands of pages of redacted declarations, and there's absolutely no guidance on how to deal with this, and there's no cross-examination, and there's nothing of that sort, that really poses a challenge. So I think this may create a question of what can we do better, perhaps, if we keep negotiating those labor provisions. And then finally, I think an open question for the floor, are free trade agreements or any trade agreements the right forum to litigate labor law violations? And that's something I pose to you. Thanks.
Right. Thanks, Colette, for a very comprehensive overview and also for those preliminary observations that I'm sure we'll come back to. I'll turn it then over to Just.
Thank you, Robert, and congratulations, Colette, for a really stunning summary of a very complicated case. So I also have lots of things I would love to talk about, and there's so much happening here. It's a really fascinating case. But I'll try to limit myself to 3 procedural technical points and then 3 more substantive systemic comments. So on the procedural technical issues, evidence, and Colette has underlined this. 2 points that you haven't referred to, so that's good. It leaves me with something to say. Amicus curiae briefs and panel compensation. So those are the 3 procedural points I'd like to hit on. And then more substantive, as you said, the crux of this case is really about what do we mean with in a manner affecting trade. And I think we really have to take this home now and think about it. Plus a few points on disadvantages of RTA dispute settlement more broadly. And really, on your last point, labor in FTAs is the hard dispute settlement mechanism really the way to go. So on evidence, you're right. So this is a stunning case in that it was decided based on redacted information. Imagine being Guatemala here, you're challenged by the opposing state and you don't have the identity, the information, the details on where this evidence comes from. So they really pushed very hard to get it. The panel took a rather deferential approach, saying, well, it's not impossible for you to figure out what cases they are referring to, and refused to even ask the US to submit the full information. So Guatemala didn't see the full information, nor did the panel see that information. The WTO can deal and has dealt with confidential information in many disputes, but it's then a question of not disclosing it to third parties. So here the panelists themselves didn't see it, and Guatemala, as defendant, was basically fighting a ghost because you don't know exactly where the evidence is coming from. On the other hand, you have the US in an equally difficult position because they got that information on a confidential basis. They promised not to share it for fear of retaliation, whether genuine or not. So thinking ahead for future cases, I think that one needs to think of a procedure allowing the panel to look at the evidence and avoiding that fear of retaliation. Interestingly, what happened amongst other things is that the US went to the ICSID Secretary General asking her, can you confirm that the evidence is correct, corresponds? And then she actually agreed to do that, and then it was submitted to the panel, and the panel was quite upset with that, rightly saying, well, you seem to trust ICSID more than you trust us as a panel here. So I think it's really important to think ahead ex ante now about procedures where this can happen, where the confidential information can be shared. Otherwise, it becomes very difficult, I think, for all sides involved to do this correctly. In the end of the day, the US lost quite a bit out of this because they couldn't really use their information to convince the panel. And one interesting point that the panel made was an explicit statement on the standard of proof, which you don't often see in WTO cases. So they wanted evidence more likely than not on the balance of probabilities, which I think is quite an interesting approach. So not at all beyond reasonable doubt or anything else. Second point on amicus curiae, and it's linked. The panel insisted that they should add, when it comes to the legal arguments, given how difficult it is to get factual evidence, I wondered whether these unions or other amicus could not add onto the factual record as well. I know it's difficult and the parties have to really build their case, but here you have a panel that took a very adversarial approach. Only the parties, not amicus, and we as a panel cannot really intervene as a result of the rules as they are written now. Amicus were admitted and the panel took them quite seriously, stressing one point: you have to be an NGO or so based on CAFTA-DR territory. So one was kicked out, which I thought was quite interesting. Last point on procedure, but again, a fundamental one, panel compensation. So the day I read this report coming out in July, I also happened to read an investor-state dispute settlement case against Canada, Mesa Power versus Canada, really literally on the same day. Now, CAFTA panelists in cases like this are paid $75 per hour. That's a cap, okay? And they cannot go per case above $19,000 per panelist. That's written in the rules. Now, in that Mesa Power case I refer to, which is an ISDS case, the payment was $550 per hour, and the chair walked away with $500,000 in compensation. Now, which really hit the point, at least in my mind, why that huge differential here. They ended up working 3 times as many hours as the cap. So the panelists working on this for years quite rightly said, look, what's going on here? You need party agreement to lift the cap, which didn't happen. So if you want to do this seriously, we need to think about evidence and then also about ways to compensate panelists. I'm sure these people will have enjoyed doing it once, but I doubt it that it will be easy now to find panelists to do this a second time. Now, more substantive points then, in a manner affecting trade. Colette, you called it a middle ground. The US said, well, if the sector is a sector where we trade, that's enough. You're right, that was probably one extreme. Guatemala said we need to have actual trade flows affected. I think the panel wanted to find a middle way, but reading the actual weighing of the evidence, it's still pretty strong in the sense of requiring actual trade effects. And at some point, which is interesting for WTO lawyers, they actually dismiss the standard WTO view on this. The standard WTO view is measures affecting trade if you can show on the face of it that competitive opportunities are affected. Theoretically, that's enough. The panel here rejected that approach and really, as you were pointing out, wanted to have a number linked to dismissal of unionists and then linking that to an actual comparative advantage conferred by this, which in a way had to be more than de minimis in terms of effect. So I think, I mean, I'm not criticizing one or the other way, but there could have been ways to do it more along the lines of the WTO. They came up with a reason saying, well, in the WTO it's about the scope of application, measures affecting trade. Here it's about condition for breach. I mean, I'm a lawyer, I love legal distinctions, but I'm not sure that one really makes sense. I mean, in the end of the day, a measure within the scope of application will breach. So in the end of the day, I don't think there is that fundamental difference. But that's probably the main thing coming out of this case. In a manner affecting trade, get your data ready. It's not enough to show that unionists were fired. You'll have to put some effect, actual comparative advantage to it, which, and I'm no labor expert, I'm curious to hear what those people think, which now makes it really hard to win these cases. Very, very hard to win these cases. More broadly, challenges of dispute settlement under regional trade agreements. I was involved in the one other case under CAFTA, Costa Rica versus El Salvador, which was a pure trade case, and I've written a little bit about once you go through this, you realize how different it is from the WTO and the practical challenges. Reading this one again, you have to reinvent the wheel about preliminary rulings, evidence, panel specificity. As in the other CAFTA ruling, what is quite stunning is that they consistently refer to WTO jurisprudence. So that's an interesting development, but it becomes a reinventing of the wheel, going through everything we are used to in the WTO, making the whole procedure rather unpredictable and very time consuming. As you said, Colette, there is no appeal, that's it. There's quite a number of dissents in this whole proceeding. Remember, the panelists, unlike in the WTO, are appointed each by the parties and then jointly a chair, which I think affects the dynamics of the whole case, which is a bit more like ISDS. Big differences. Once again, if anything, confirming that there's a lot of reasons to come to the WTO rather than regional trade agreement dispute settlement. Final point, enforcing labor through trade agreements. But as you know, there's two main models out there. There's the EU model and there's the US model. The day this report came out, I was at a meeting in Paris. The EU Commission was presenting there on related environmental issues. They took this whole case as a vindication of their approach. The softer approach is much better than the harder approach that the US opted for. This case took a lot of time. A lot of suspensions happened. But the EU was basically highlighting its model as a softer approach. You have trade unions involved, civil society involved. You have many more collaborative processes happening, working towards a solution, rather than this adversarial system, which in the end of the day didn't deliver anything for the US. I mean, imagine if the US had won this case, the remedy is one of an annual monetary assessment, so a money amount that Guatemala would have to pay, which I guess has to be somehow equivalent to the trade effect, which by definition would be relatively low. So you can ask yourself, what's the whole point of this? Or the money then has to go, I assume, to some labor efforts within Guatemala. But the EU would say, well, our system of positively working together is much better than this adversarial system of using trade sanctions to enhance labor compliance. Now, the last point I want to make, because I just came back from the US teaching there for 3 weeks, to my surprise, this case is taken by trade unions in the US as a reason to push for even harder enforcement, dispute settlement mechanisms and trade agreements. As I said, I would think twice about this before doing this. If you ask me, the point where you can improve labor is the point when you conclude the trade agreements. Apparently Mexico has engaged in quite a number of domestic labor reforms in the lead up to TPP. The collaborative approach of the EU, I think, needs to be looked at. There's lots of cases, actually, not dispute settlement cases, but cases in these committees, including with Korea, with Guatemala, that are proceeding in a much more positive way. And the last point, I think Robert referred to it, there's a backlash against globalization, and people losing jobs is one of the big points. Unions and lots of people are putting everything in these labor chapters, the way they are playing out now. I doubt whether these chapters will solve the problem, whether they are even going at the core of the question of backlash, redistribution, people losing their jobs. So I think we should take this case, learn from it, and make adjustments, not just in the next case, but really in how we negotiate free trade agreements and labor chapters. But from what I can get, and I'm curious to hear what our commentator from Washington will say, my sense is that the lesson has not been digested, and I would hope we can really use this report in a positive way to improve what everyone, I think, really wants to achieve, that is higher levels of labor compliance and dealing with the distributive effects of liberalized trade. Thank you.
Great. Thanks, Houston, for some very interesting comments on both the procedural and substantive elements, and certainly some things to think about for some lessons learned and what we do as a result of this. Let's now turn then to the labor side of this and hear from Pablo.
Okay, thank you very much. And first, let me thank the ICTSD and WTI for this invitation. And I'm very honored to be in this panel since I have been working on this for about 15 years in the discussions and in the negotiations of free trade agreements, especially with US and other partners. And so I have had the opportunity to negotiate this and now to comment on the first ever panel. So it's very interesting. I'm very excited as well with this. And congratulations, Colette, for resuming in 10 minutes 200 pages of, of findings in these talkings. Well, let me first of all say that this is not new. We have discussed this. I mean, the world has been discussing this from at least 1919, when ILO was created, in the sense that it was an issue of having labor laws in the international arena for avoiding unfair competition from those who were not complying with the higher standards. So this is what we have in the preamble of WTO. But then in the almost 20 years ahead, we have had discussions on the global multilateralism in Copenhagen, for instance, 1995, in Singapore with the WTO declaration in 1996, then in 1998 with the ILO Declaration of Fundamental Principles on Right at Work and its follow-up, and in UN ECOSOC with the Ministerial Declaration in 2006, and ILO Declaration on Social Justice for Fair Globalization 2008, and UN 2030 Agenda on Sustainable Development. What are the main issues of these documents? First, we have to deal with a civilization which is dealing with the globalization. And globalization affects, of course, workers and of different countries in a different way. And if you have free trade agreements, or you have to develop openness in your countries, you must deal with those who are losing their jobs, with those who are losing some of their rights. And because if not, it's a question of legitimacy of the model for the whole world. And that is why in Copenhagen with the heads of state, and in WTO with Singapore, and all these events, people were building a new consensus, in the sense that you must not deal with trade issues without having at least a concern with labor rights, with environment as well, and with civilization as a whole. And the latest instrument is, of course, the UN 2030 Agenda for Sustainable Development, which says in a slogan, "No one left behind." I mean, that sense that you cannot go on with the economics without taking concern of the people, of the working people, of the people, consumers at large, in some you cannot go on without taking care of inequalities and fighting against poverty if you want to have legitimacy in the economics. Some facts, there has been an evolution from unilateral measures to bilateral and regional discussions. For instance, SGP's system and models, unilaterals from some countries like the US or European Union, going to bilaterals in the FTAs and in regional agreements. Why is this? Because there has not been room to discuss this in WTO rules because of the lack of consensus. And so we see as well that there is an increasing and deepening of the linkage between trade and labor within the models of the FTAs. For instance, the US model has evolved at least 4 times, and fifth if you count with the TPP. This CAFTA was the 3rd generation, but we are going now at least by the 5th with the TPP model. And so, there is a trend because since the first ever agreement with labor clauses, the NAFTA, we have now in 2014, 2,060 FTAs and 77 with labor clauses. So that creates a risk of distortion because some countries are with labor clauses in their free trade agreements and the others do not have these clauses. There is still no room for multilateral discussions because WTO doesn't accept to discuss this, at least by now. And in this context, this US-Guatemala case is the only ever to have a report on a labor dispute in an FTA, even though we can observe that many consultations proceedings have been conducted, especially under the U.S. Agreements. And no one has challenged in WTO anytime, anywhere, a measure dealing with labor issues. Even if we see some measures of some countries addressing some labor issues, but without being challenged. And interestingly, there is no evidence of protectionist use of labor clauses until now. I mean, in the sense that even in the consultation processes we have observed right now, there was a typical issue of labor cases, but not anyone has claimed about protectionist use of these instruments. There have been, as well, on the other side, interesting comment on this, and very much positive experience on cooperation, and in the sense that the European Union model has been working on instead of this kind of disputes. But even though the US and Canada model, which have this kind of sanctions, have been very cooperative as well. So there is a combination here between the part of cooperation and the part of dispute settlement. And relatively some cases related with the GSP systems. So what kind of provisions we see in many of the FTAs where there is a question of decent work concept, fundamental labor rights. In some cases, there is the other concept of internationally recognized labor rights, which is slightly different. Of course, many of the agreements talk about the enforcement, due enforcement of these provisions. There is a question of non-derogation principles in the sense that do not change your rules for improving your competitive advantage. Question of transparency, cooperation, seriousness, and this seriousness goes from the cooperative approach within the EU model to the dispute settlement panels with the Canadian and the US approach. And there is a question as well of how to make participation of social partners. A little slide to show the south of Chile, to make propaganda here, because now we are entering in the dark side of the force. This is some comments on the Guatemala labor case. Well, as Colette said, and Josh confirmed, this is the first ever report on labor issues linked to trade. So that creates an important interpretive, very important leading case with important interpretative issues. Of course, any panel in the future will refer to this panel, because that is the importance. The rules here were the CAFTA rules, especially in the labor chapter, and in the dispute settlement chapter, but it was not clear whether the WTO rules were going to apply. But finally, both parties, as the panel said, incorporates in the discussion on their behalf the principles and the rules of WTO and the jurisprudence, and the panel did as well. So we are all linking the principles of WTO and the jurisprudence of WTO in this case. And because of that, normally we're going to have that in the future cases as well. There were no protectionism allegations here. So that was the main concern in the big discussions in 1994, 1996, 1998, that these were rules that were going to be used in a protectionist way. Well, there was no case here, and that is important. And there are different views, of course, on what and how to prove, but I refer to Colette's observations and Jo's as well in this, because we have not much time. What the interpretative issues important after my view, in my personal opinion, thanks. Labor law enforcement. There was a question about just enforcement of administrative issues, or was it the enforcement by tribunals? Because normally the enforcement agencies are from the executive branch, but the panel said that enforcement was including as well the tribunal's activity, and so failing from the tribunals was also a question to be discussed during this panel. Of course, it was a question of what to understand about effectively enforcing. This very interesting discussion during the panel about the standard. What is effectively enforced? What is the limit of this obligation? Does it mean that you must enforce every day, every time, in every activity, in every working place? Of course not, but what is the concept? And so it was very important ruling here. It was, of course, very interesting, the question of the anonymous documents, and as Josh said, it was a very difficult task for Guatemala to deal with this, and of course, on the other side, for U.S. to present this kind of proofs, because they were arguing that if not, they were not going to put any documents, and because of the character of this trial, of this panel, it was important to show evidence different that those normally written on papers. And of course, it was very important to distinguish when and how sustained and recurring course of action or inaction could be defined. And of course, in a manner affecting trade, the jowl of the crown here is the main concept to be understood. there was also a question of the burden of proof on reasonable exercise of discretion, bona fide discretion of parties, because the party has the right to see how to allow to the allocation, what is the allocation of the enforced agencies, and the question of NGOs' participation. Well, you know the statement of the panel. That is the final important provision that panel gives to us. And other issues important on jurisdiction, measures and legal basis for complaint, but Colette already stayed on this, and the question of the Secretary General of the ICSD statement, which creates a lot of difficulties within the panel to allow this kind of model to allow the redacted evidence. There were no proofs on the hearings, no witnesses, no reports, experts, and no one, and no cross-examination as well. And post-panel request fact evidence has been also discussed. Relevance on this for the ILO's Committee of Expert Interpretation on the 1998 Declaration, very important. And principle of systems integration, I resend you to footnote 3 to 7. Possible consequences, some have been putting this in the paper. Different readings on the report, of course, in the US and in Guatemala, but we have also a EU discussion in the European Union on whether this is the model to follow or how. Is there a room to discuss, and this I put this question to the audience, to discuss this on WTO or in ILO or in UN? There are some discussions and responses, but not mature enough to give you any response. And how about worker rights? Has been this positive consequence for the workers finally in the US or in Guatemala, and that is something we must find out after, in some period after this. Because finally, what is the purpose of these free trade agreements and the labor clauses? It's about civilization. It's about improving living standards. It's about improving labor rights. It's not just about trade and investment. It's about civilization. And current global current key issues, of course, we will continue discussing about what is the preferential approach, cooperative or trade sanction preferential approach, because we have different level of development among parties and different commitments to be suggested, and the question open to everybody and how to enhance social partners' participation. I have here a slide on the experience of Chile within this, but I have no time to discuss on this, and so the conclusions finally on this CAFTA report. Important first report on trade and labor, not only for the final statement, but for the criteria developing in all discussing issues, and politically and legally very extremely relevant. Thank you very much.
Great, thank you, Pablo. Thanks for that comprehensive presentation, in particular walking us through the evolution of the linkages between trade and labor, and also identifying some of the implications and interpretive issues that are likely going to preoccupy us for a while. Lastly, then, to our last speaker, we'll go over virtually at least to Washington to hear from Doug and the U.S. policy perspective on this. Doug, if everything's worked properly, then...
I hope you can hear me fine. Is it coming through loud and clear?
Yep, you're on.
Okay, great. Well, first, I'd like to thank you all for inviting me to participate, and I'm sorry that I can't be there in person and that you all have to listen to me remotely by video. So I ask for your patience on that. I would say just to start with, that this ruling was both surprising and anticlimactic. Surprising in the sense that the U.S. spent such a long time working on this case, and tying the Obama administration, tying it so closely to consideration of the TPP, that it was kind of shocking that when the ruling finally came, it wasn't in the U.S. favor. It was also sort of anticlimactic, though, because one could imagine if this ruling had come out a year earlier and was the same ruling, that it would have had quite a big impact on the TPP debate. It would have, given validity to all of the arguments that people were making against the TPP. I mean, against having yet another free trade agreement with developing countries like Vietnam, Malaysia, and Brunei, where there's concerns over labor practices, and it would have really raised questions about the ability of trade agreements to be meaningfully enforceable when it comes to labor rights. But instead, by the time the ruling came out, Trump had already withdrawn from the TPP, and it just didn't really have as much impact here as I think it would have if it had come out earlier. There was predictable disappointment on the part of the U.S. Trade Representative's office, who basically said, that the tribunal got it wrong when it said that it didn't affect trade for all the reasons that the other panelists have explained. And then the Democrats in Congress, who mainly advocated these type of provisions, also blasted the ruling as wrong-headed. So. It was very interesting, but as I say, anticlimactic at the time it came. I'm not really a trade expert. I'm just a reporter who writes about trade agreements, and I'm certainly not an expert on labor law. So, I kind of feel like I'm on shaky ground there. What I do know about is sort of this impetus or this push over the last 20 years to bring labor provisions into trade agreements, mainly to help build the political support for them to get passed through Congress. And, generally, I would say that labor groups here in the United States, and I'm sure in the European Union as well, feel like labor protections in developing countries like Guatemala and Mexico are not as strong as they are in the United States, and therefore those countries have an unfair advantage, over workers here, and they also feel that is pulling jobs away from the United States. So they have sort of like selfish and unselfish reasons for seeking strong labor protections and trade agreements. One, they want to keep jobs here and raise wages, and two, I think they're generally interested in raising conditions for workers in other developing countries. So, like I said, all of that has led to more and more attention to labor concerns in trade agreements over the past 20 years. But I would say, despite that increased attention, labor groups and Democrats are still reluctant to support trade agreements. They still feel like labor provisions, labor concerns are not adequately addressed in these pacts, and this agreement is this decision is just going to give further weight to those concerns. Some people charge that labor unions are continually moving the goalposts when it comes to trade agreements, that they ask for one concern to be addressed, and when that concern is addressed, that another concern is raised, and you can basically never satisfy the labor unions. And I don't know that that's completely true. I think it's more likely that U.S. administrations And it's really too early to draw a conclusion about the Trump administration, or at least previous U.S. administrations generally just don't see the issue the same way that labor groups do. And, my impression is that U.S. negotiators have generally believed that the purpose of trade agreements is to expand trade between countries. And I think that they're a little bit wary of including strong labor provisions that could restrict trade. I mean, that's just my view of what they think. I'm not speaking on their behalf by any means. So, so I think that they've sort of treaded carefully when it comes to labor provisions in trade agreements. And I think, again, that's kind of reflected in the decision of this case. And I think there are reasons that they have to kind of tread a fine line, because one, they face resistance from developing country partners who have to open their markets as a result of the trade agreements, and they don't want the concessions that they have bargained for just to be taken away as a result of, a hair trigger labor dispute settlement action. And two, administrations face resistance from Republicans in Congress to make labor provisions too strong. And I think there are a number of reasons for this. One is that Republicans generally want trade agreements to be trade expanding, not trade restricting, and they fear that strong labor provisions, may thwart that. Two, Republicans don't want U.S. labor practices subject to dispute settlement. And three, Republicans possibly don't want to give their opponents a key victory because labor groups mainly support Democrats. So this has kind of forced U.S. administrations towards provisions that both developing countries and Republicans can accept more than towards those demanded by Democrats and labor groups. Even so, there has been an evolution in how trade agreements handle labor provisions over the last 20 years. And probably many of you in the room know this. So I apologize for going over something that you probably already know. But, the original NAFTA agreement that was negotiated by the Republican administration of George Herbert Walker Bush, it didn't have comprehensive labor or environmental provisions in the agreement. However, when the Democratic administration of Bill Clinton came into office, he negotiated labor and environmental side deals to get NAFTA through Congress. And, basically, under that side agreement, the countries, Canada, Mexico, United States, agreed to enforce their own labor laws. However, that commitment was not enforceable through the same mechanism as for the commercial provisions of the pact. So ultimately, trade sanctions could not be applied. And labor groups, kind of view this as a big inequity. Other provisions are protected by the threat of trade sanctions. Why can't labor provisions be protected? So the Clinton administration, when it finally negotiated a trade agreement of its own with Jordan, it made both the labor and the commercial provisions equally enforceable. But, Republicans were in charge of Congress, and then George W. Bush won the next election, and Republicans at that time were concerned about using sanctions to enforce labor provisions of trade agreements. So basically, the governments of Jordan and the United States exchanged letters that said if any dispute arises, we'll try to resolve it without using trade sanctions. So that was kind of the second model of trade agreements. Then came CAFTA and a number of other trade agreements that were all sort of negotiated in the early 2000s to the mid 2000s, and they also include labor in the text of the agreement, and they have this pledge that we've been talking about all day that they would not fail to enforce labor laws in a manner affecting trade. And it has been discussed. They set up a different dispute settlement system for labor complaints. They allowed for monetary fines for trade sanctions. Then after all of that, there came what is known in the United States as the May 10th Agreement. And this was sort of a pivotal agreement in the evolution of trade agreements here in the United States. And it concerned a lot of different issues, but was mainly about labor. And this was struck between the Bush administration and Congress in order to help get 4 trade agreements through Congress. Those were with Peru, Panama, Colombia, and South Korea. And basically, that deal strengthened the labor provisions in those acts by requiring those countries to adopt and maintain in their laws and practices the International Labor Organization's Declaration on Fundamental Principles and Rights at Work. And I'm sure you all know those, but those are, freedom of association and right to collective bargaining, the elimination of all forms of forced or compulsory labor, the effective abolition of child labor, the elimination of discrimination in respect of employment and occupation. So those May 10th commitments were also enforceable through the same dispute settlement system as the commercial provisions, and there were no limits on monetary fines, and there was a possibility of trade sanctions if the offending practices were not corrected. So it was stronger than what's in CAFTA, but my understanding, it still has this clause where you have to show that violations have affected trade. And then finally, we came to the TPP model being negotiated by the Obama administration, and it went even further, and it added additional additional provisions to the May 10 approach that included language on minimum wage, forced labor, and generally encouraging companies to improve their labor practices. However, as I said earlier, despite this trend towards stronger labor provisions, there has been a hemorrhaging of democratic support for trade agreements, particularly in the House of Representatives. For example, when NAFTA was passed in 1993, it was passed by a vote of 234 to 200. That was fairly tight, but still a comfortable margin compared to some other trade votes. And at that time, the yes votes were fairly evenly split. There was 102 Republicans who voted yes, and 102 Democrats who voted yes. So basically, the yes was split 56-44% between the two parties. But when CAFTA, the trade agreement that we're discussing today, when it came up for a vote in 2005, it only passed by a vote of 217 to 215. And in that tally, Republicans provided 93% of the yes votes, and Democrats only provided 7% of the yes votes. And that was kind of like the low water mark. It has bounced back a bit since then in votes on other trade agreements, but the level of Democratic support doesn't quite, you're not getting 102 Democrats voting for trade agreements again. It just doesn't happen. So, and then, right. For example, the trade agreement with Colombia, for example, was hung up for years, along with the agreements with Panama and South Korea, although I think principally it was the agreement with Colombia that was the problem. And that was basically because Democrats were concerned about having a trade agreement with Colombia, which they called one of the most violent countries on earth, and that there's this long history of violence against trade unionists in Colombia, and nobody's ever prosecuted for the crime. So it was something that unions were very strongly opposed to, and it was very difficult for Democrats to vote for that. And so that presented a real conundrum for the Obama administration, and they came up with this detailed action plan to address these labor concerns in Colombia and make it more palatable for Democrats to vote for it. And even so, when it came to the floor, only 31 Democrats voted for it. And then finally, we get to the vote on Trade Promotion Authority in 2015, which I think a lot of people saw a proxy for the TPP, although the CPP has never come to a vote. But in that vote on Trade Promotion Authority, only 28 House Democrats voted for it compared to 190 Republicans. So, I think that those numbers kind of explain why the language ends up like it is, because, you have to just, I think the administrations have to be sensitive to the people who supply the bulk of the votes for the trade agreements. Now, I mean, you could argue that maybe they would get more Democratic votes if they lean, harder, if they lean towards stronger, more aggressive languages that would be made it easier to impose trade sanctions. And that may be true, and maybe the Trump administration will decide to go in that direction. But the decision that administrations have to face is that we know we have a group of people who will vote for trade agreements if we do this, this, and this, and don't do that, and that, and then. The question is, can you forge a new coalition if you change, your list of ingredients for what goes into a trade deal? So, it's been commented on already, but it was really an extraordinary length of time to reach a decision in this case. It was filed in the last year of the Bush administration, and we didn't get the decision until the first year of the Trump administration. And I know that union groups were really disappointed with the process. They felt like a lot of the evidence got stale, and the delays also sort of seemed political, to some degree. Whether or not that's true, I can't say, but it did sort of seem like, the Bush administration was stuck on Colombia. They couldn't get Colombia through Congress, so they launched a case against Guatemala on labor rights, and then nothing much happened. And then the Obama administration found itself stuck on Colombia, couldn't get it through Congress. So in addition to the action plan, they restart the litigation against Guatemala, and then, it gets suspended for a number of years. And then finally, the Obama administration wants to get TPP through Congress. And lo and behold, the Colombia case starts moving forward again.
Doug, sorry to interrupt, but given the advancing time here, can I maybe ask it just a few sentences to wrap up, and then we'll move over to questions from the audience.
Oh yeah, I'm sorry. I've been rambling. So anyway, so that created a lot of cynicism about the process. I'll leave it at that.
Well, thanks a lot. It was all very interesting.
Yeah.
It's just that we have a limited amount of time and a lot of interest here to get into some discussions and questions. But thanks anyway also for the sharing with us the reaction in the U.S. to the dispute, and also to sharing the political dynamics and the evolving political dynamics in the U.S. in the area of linking trade and labor. Normally what we would do here is we would go one more time around and give each panelist 2 minutes to comment on what they've heard from others. But we've got about 20 minutes left, and I think there's probably going to be a lot of interest in the discussion here. And I know, in fact, that there are some people in the audience that have probably more knowledge about some of the intricacies of this dispute than even the already very excellent panel we've had, and we would like to have an opportunity to hear from them as well. So I think we'll pass on the 2 minute round here, and if you do want to if any of you want to make some comments on things that you've heard from other panelists in the context of a question, you can come in and make a brief intervention on that front. So at this point then we turn it over to questions either from those of you that are physically present here, or if anybody's watching the streaming, you can post a question online. And in fact, even if you are in here and you want to post a question either on Twitter or online, we can have that relayed through the staff here. I would ask you to introduce yourself when you make your comment and question. And comments are also, just to be clear, comments are also welcome. It doesn't need to be a question. We want to hear from all of you. So, who wants to go first? I'm sure there's lots of interest. Okay, back here.
It's an open question. The heart of the matter is when we relate sustainable development issues to trade, how do we effectively enforce or connect trade with trade issues or trade as such, liberalization of trade with concerns regarding sustainable development. There are two approaches available, US sanctions and EU soft law. Both are in process of, we are witnessing as to what's really happening, but I'm just concerned as to the fact that we cannot effectively link legally the issues unless we get inside the trade issues and sensitively link sustainable development within trade issues. If we go general, then it's only through trade diplomacy can we connect or push these sustainable development issues. It seems like a comment, but it's just general. I just wish to know your understanding on that.
Okay, thank you for that question. We'll collect a couple of questions before we come back to the panelists. Here.
Thank you. My name is Kent Vilska. I'm from the Ministry for Foreign Affairs of Finland, responsible also for trade and labor rules in the free trade agreements. Has been discussed that this kind of two approaches to kind of more collaborative and perhaps the more kind of litigation based. And my question is that do you have to really choose from one or the other? Why wouldn't it be possible to combine? And I mean that could you see a kind of that this kind of broad approach where there would be narrowly a defined set of commitments and the violation of which then could affect actual trade flows between the parties, and you could then have those paragraphs under the general dispute settlement mechanism, and then the more aspirational you would have the more collaborative approach. Is this kind of combination of the two approaches possible, or is it really that you have to choose one or the other? Thank you.
Interesting question. Thank you. Here.
More of a policy question, I suppose. And this starts off with what Pablo ended with as to the fact that this is not about trade, this is about civilization. But is it really true if you see the fact that, and Colette mentioned this, that the only enforceable obligation was the one which related to trade? And possibly something, if you look at the chapter, labor chapter itself, like 16.3, where you have procedural guarantees, if you enforce those, or if you are more strict about those, then maybe you really are serious about non-trade concerns. But it would seem that FTAs like this, where labor chapters only enforce or only allow enforcement of those obligations which relate to trade, I guess the concern still with many countries like the United States is still trade and not so much about labor. And I guess this falls back onto a subset, another question, which is how far do we want a unification, if you will, of labor rules and other non-trade rules? I mean, we have the ILO, etc., but is this sort of streamlining of more domestic concerns still something that we want to have in our trade platforms? And yeah.
Thank you for that. We'll take one more question, and I think we'll take it from online. Christine? Yep.
This is a question from an online viewer, James Harrison, and it's a question for you, Pauline, specifically, but other panelists, if they wish to respond. and it's the following. There is now significant evidence from academic studies to suggest that the EU's more cooperative approach also has serious failures and limitations. So are there other ideas for how we might more effectively tackle the backlash against globalization to ensure distributive justice from trade in future trade agreements? Are there other legal or policy mechanisms we can use on this issue?
Thank you. So we have 4 questions and some sub-questions here. Give them to the panelists. You don't have to feel like you can answer all of them.
Thank you. I'll try to combine the question of the gentleman in front here and the lady in the back, and touch upon the question of the Finnish diplomat in the process. So I think one issue to be careful with is we need to be careful to. Well, let me rephrase it. When you're litigating under free trade agreements, you're by definition dealing with issues affecting trade. Right? Otherwise, why would the U.S. be telling Guatemala what to do domestically vis-a-vis any type of issue? And so, I agree that we should find a way to enforce sustainable development and human rights issues. And reading this case, it reads like this should be addressed. There are serious labor violations going on here, but the question is, should they be addressed in the FTA with the U.S. and should the U.S. be the one that is enforcing this? Because it's also an element of sovereignty, right? So part of the sovereignty that's created in the trade agreements is on the basis of the rationale that these forcing labor laws affects trade. So where does that line lie? And I mean, just commenting on something what Joost was saying earlier, if the panel has created a standard that is higher than affecting trade as it is defined in WTO, did they do that correctly or not? To what extent is it important to have this as a strong link in your agreement, right? So that doesn't answer the question on how we can then better enforce labor provisions or ensure sustainable development takes place. But I think it's important to note the sovereignty element here as well. On the question of soft versus hard approach in terms of how to go about labor provisions and whether there's a way in the middle. Well, I think that the CAFTA-DR in a way is a way in the middle because there was only one provision of the trade agreement that was in fact enforceable, and that was the one that dealt with enforcing the rights and obligations. So it was a pretty serious one, and the reason that this one was enforced was because in the process of negotiating this trade agreement, there was a key concern, not just that the countries didn't have the right labor laws in the books, but actually how they were implemented. So that's how that one became, in part, one of the ones that was enforceable. So, I mean, I think it's a very interesting approach. I also think that the combination of the hard and soft approach is visible in this case by the first couple of years where they tried to come up with a mutually cooperative agreement. And in fact, there was an agreement, or the Office of Labor, the ODLAB, essentially they came up with a public report with a number of recommendations. And throughout the years, and also during the period of suspension, they tried, in fact, to enforce those recommendations. So it's almost like there was a little bit of both here. And what I'm worried about is that it seemed like dispute settlement, like the hard way, was kind of, the stick, the carrot and the stick approach. And this was the stick. If you don't resolve it through this collaborative matter, then we're going to go and back to the dispute. And I'm worried that with this outcome, that stick has lost a little bit of its force.
Joost, you ready?
Yeah. So you're right. There's ways to combine it, but how to link it up, how to link trade to these other issues. When I was discussing this in my trade law class, I mean, a couple of students were saying, a bit like what Colette was saying, isn't the fact that this is in an FTA enough of a link to trade? But they've added this language in a manner affecting trade, so we have to give meaning to it. But as I was saying, Pablo, you said they incorporated everything of the WTO except on the really important issue. There they took a different interpretation, which now may undermine the stick that was available. Now, either the next panel will look at this differently, this is just one panel, but perhaps this will have precedential value. even though technically it shouldn't. But negotiators will have to look back at the language now. I was looking at TPP. It includes exactly the same language in a manner affecting trade or investment. The CETA has something similar, to encourage trade or investment. What does to encourage trade or investment mean? So it's legal technical, but it goes to, how do we define the link? The online question, it's true that there's been especially an issue with labor in Korea under the EU-Korea FTA, where probably they've reached the limits of the collaborative approach, and some NGOs in the EU are saying we need the stick. So it may be useful to have the stick at times, but if you think of it, 9 years of litigation, what did Guatemala pay lawyers, travel? They could have spent all of that on improving labor standards in Guatemala. So I'm really torn as to, yes, we need to have the stick in the background, but we should really avoid using it too often. And if we do use it, it seems now it's gone. Alternatives, as I said, before signing on to the FTA, I think you could really push a government to say, look, you're not going to get all of these benefits unless you change this and that in your law. And if you don't do it now, we won't ratify the FTA with you. You could have a review, a bit like what they have in the GSP system, and you kick a country off the benefits. But there must be other ways to do it. And I think Doug referred to this. My worry is that trade unions focus all of their attention on this one issue of compliance with labor standards outside of the US. I'm sure it's an issue, but they put all of their money on that. To me, the backlash is a lot more about people within the US losing jobs and doing something about that. So alternatives there is redistribution, thinking about how can we compensate the losers from trade. Because if you put a labor chapter into an FTA, as a negotiator, you have to pay for that. So the EU, the US, arguably are paying now by having these chapters in their FTAs in terms of trade concessions and what have you, with little in return. And my only question I wanted to pose was, is that really the thing labor unions should focus on? Shouldn't they shift the attention at least to this perhaps, but also to other issues?
Thanks, Just. Pablo.
Thank you. Yes, this gives a lot of issues to reflect on, and of course, when you are dealing with the negotiations itself regarding the question of Finland representative, each country and each bloc has its own rules, and there are many people dealing with free trade agreements and labor clauses in the world. So it's not just US and it's not just the European Union. You have New Zealand, you have Australia, you have Asian countries. We have a model as well as Chilean government. We have pushed for free trade agreements in a cooperative way, and we have, for instance, an agreement with China with this issue. So different models to be implemented in different ways. But this creates, of course, a kind of distortion. So the best would be to have a discussion on how to deal with these issues regarding the whole system. But we are far from that, as we understand, very far. Perhaps you could have an understanding between United States and European Union, but with the decision of U.S. administration now, that sounds very difficult, politically very difficult. So it's not real policy. And of course, it is about sustainable development, not as a broad concept, in the sense that how we would like to see our future with the trade issues, investment issues, but along with providing protection to our climate, to our civilization, to our people. So that is a big question, but we have no unique answers. We have the OECD answer with the OECD guidelines. We have the UN principles on human rights and business and human rights. We have many responses, social responsibility issues, instruments as well. Many responses. The ILO declaration of how to treat with the multinationals. Because in all kind of political forum, we have the concern of how to give legitimacy to the system, to the economics and to the trade and investment issues, not just making trade something in itself, a purpose in itself, but an instrument for the people behavior and for the people well-being. And well, we could discuss a lot of more, but I rest with that.
Thanks, Pablo. Doug, I'll turn it over to you for a few reactions to some of the questions.
Hi, yeah, I'll just, can you hear me all right? I'll just talk about the collaboration versus litigation issue. And I guess, my guess is that U.S. trade officials, Department of Labor officials, I mean, they would be probably more inclined to try to resolve this through collaboration. But there's just pressure to show results, to show progress, and you work with another country, and you may make progress over time, and their labor regime may be improved, but it's not as visible politically as bringing a trade dispute and getting a win. And so I think that's why administrations bring trade cases to some degree, and why they bring labor cases. So I think just kind of an unfortunate aspect of the political system here in the United States that you kind of are forced towards the litigation aspect of it.
Great, thanks for those comments from all of you. Let's go back to the audience in for another round. Back here.
Thanks. I had a few questions, sort of two observations really, but I'd be really curious to hear the different panelists' responses to those. What I find really striking in this case, and in a way these two parts of my comments are going to be somewhat abstract because I am aware of the politics and dynamics around it, but two things do strike me. First of all, we know that there's a tension between comparative advantage, in which case a country should be able to derive benefit from, for instance, lower labor standards. So the tension between comparative advantage and this race to the bottom, which is what a lot of the sort of anti-globalization critics are expressing concern about. And this case, it seems, sort of highlights this in the sense that ideally, if this chapter had been well framed, or if the case had gone out as one might ideally want, it'd be in a sense this case would have the scope, or this kind of approach would have the scope for saying this is we can't go lower than this in terms of global competition. It's a sort of sense of, okay, comparative advantage, fine, but there's a human level at which or below which we can't go, and then you could think of that kind of approach regarding tax incentives or the other areas, environmental standards, the other areas on which countries actually do compete. So that was sort of one observation, but I'd be curious to get your feedback. And the other one is this: the other paradox that I see in this case is that, in a sense, the U.S. is asking the Guatemalan government to regulate its private companies. And there again, I mean, that's such a stark contrast with the kind of, investment disputes typically we hear about. And so I find these two issues very striking in a sense. I mean, again, as I said, I know that sort of in the abstract and that the issue is more complex, but I was curious to know if this strike, if there's any potential there, and that strikes any of the panelists also. And Colette mentioned the word sovereignty, actually, where I used the word regulation, and Colette used the word sovereignty, which is kind of the other the flip side of the same coin. And another point, which a separate point, is that we've talked about is the trade system the best way to enforce labour standards, and you just made the very good point of how much did this cost both governments actually, and couldn't that money have been spent actually helping improve labour standards? But there's hardly been mentioned the fact that there's a very strong labour regime. So what does this kind of case and this kind of approach say about the continued separation of different global regimes, and why? I mean, and I believe I'm aware of the answer, but again, in an abstract sense, one should pose the question: why is the U.S. investing so much, through the trade system, about Guatemala's labour law, where the same amount of resources strengthening the multilateral labour system or domestic capacity for labour rights would probably be more effective?
Great, thanks for those questions. As before, we'll take a couple of questions before we go to the panelists. Right here.
Thank you. So I'm thinking about it from a developing country perspective and from an investment perspective, because there's risks. All developing countries are competing for FDI, and to do that, they might want to relax their labor laws to not have such high minimum wage, so that they can benefit they can compete with other developing countries. So in that case, then I think my dilemma would be, if I was a policymaker, am I going to push for very high labor standards to protect human dignity, or am I going to relax them so as to attract FDI and to deal with unemployment and those kinds of issues? So I'd like to know your opinion on that. Who pushes the agenda for labor reforms, and how do you strike the balance from a developing country perspective?
Great, thanks. Other questions? Just 1 second. Back here, Marco Tullio.
Thank you, Rob, and thank you for the presentations. I was a little bit hesitant in taking the floor to make a couple of comments, but I cannot resist. My name is Marco Molina. I was one of the lawyers involved in this case for Guatemala. And I tend to see that there is a notion that when it comes to labor enforcement, there is always this idea that our developing countries, those not enforcing labor laws. And we made the point during this case and our second written submission that that was not the case also with the United States, and we provided some examples of labor laws violations or lack of enforcement during this case. I'm not accusing the United States, but it's just to give the sense that all countries may have problems in enforcing labor laws. And this is what is interesting in the report when the panel acknowledged that the CAFTA-DR is not requesting parties to have 100% of compliance when it comes to labor laws, because there will be inevitably some sort of lack of compliance for whatever reason in different jurisdictions. That's one issue. The second, I would be more careful in asserting that in Guatemala are serious labor laws violations, because if we see what the panel found, the factual findings were based on anonymous statements, basically. And neither the panel nor Guatemala had the opportunity to cross-examine these witnesses. While we understand the rationale behind the panel's findings, just giving the opportunity to one of the parties to make its case, and nevertheless it was not possible with this kind of evidence, it is important also to note that it will be, and this is a question for lawyers, it will be very easy to make a story around a document with redacted information and trying to make a linkage between from a linkage between an anonymous statement and a document that has redacted information. So I wouldn't be so sure that the factual findings actually made by the panel in the case of 7 companies actually shows that in Guatemala we have serious labor laws violations. And the final comment perhaps is it is true that it is important, and we don't see anything wrong with having labor chapters in FTAs. I think it is a good thing. We saw good progress in Guatemala in terms of implementation and enforcement of labor laws. If you check the record, what happened before this case, you will find that Guatemala implemented almost the totality of the demands made by the United States through the different action plans that we signed. Some of the actions that we couldn't take at the moment were amendments to domestic legislation that were unconstitutional, and nevertheless we took those into consideration and we amended our legislation. Nevertheless, if you see in Chapter 16, it says that this chapter shall not be used by the parties to change the labor standards. So we have to put this in perspective. I believe this was a very important case, not only for Guatemala, but also for all parties that have an FTA, including labor chapters. I believe that there are many issues that could be improved. There were some comments or comparisons between a collaborative or a more contentious approach. And from experience, I can say and I can tell that we had preferred to continue in the comparative efforts with the United States. We made a lot of progress together when we were cooperating together. And that cooperation stopped the moment they decided to resume litigation. So as Jules was saying, there were a lot of money involved in these disputes, a lot of time and efforts. And nevertheless, the commitment of Guatemala in applying the domestic legislation on labor remained and continues to be the case today. We continue to make amendments to our system and improving our system in spite of the results of this dispute. And perhaps with those comments, I will stop there. Thank you very much.
Great. Thanks for adding those, Marco Tulio. And we had a question from online.
There are actually a few questions. There are 4. Should I read the 4 of them? Or?
Yeah, read all 4, and then we'll leave them to.
Okay, so the first question is from Diego Macal. He states that he welcomes the fact that labor provisions are built into CAFTA-DR. However, if a country trades with more than one country, which is generally the case, would it be possible for said country to agree to multiple labor provisions? So, for example, if Central America has the FTA with the United States, there's also an agreement with the EU, and if the EU requires a labor clause, which mechanism should Central America adhere to? The second question is for Pablo Lazo Grandi, and is from Lisa Baronchini. She says that you mentioned that there is some legislation on labor and trade which has not been challenged at the WTO. Which legislation is this? The third question comes from Ana Repetza, and is the following. How the U.S. CAFTA-DR report on the labor dispute should affect the renegotiation of NAFTA labor provisions. And the last question is a question coming from Jan Frederick Truman, and it's a question for Jus Pauline. Do you think the formulation measures related to trade commonly used in European trade agreements make such a labor provision better enforceable?
Great. Thanks for those questions, and thanks to the audience online that asked those. Let's this time start with Pablo and go around the panelists again to get answers again, only on the questions you feel the most able to respond. You don't need to respond to all of them.
Well, thank you very much for these questions and comments. Of course, this is a big discussion about the comparative advantages and the tension with the race to the bottom. Yes, of course, this depends on your point of view. If you are in a developed country or you are in the developing country, you will raise a question of race to the bottom or to have access to development. So regarding those parameters, you will have different answers from where you come from. Regarding the minimum wages from the lady, the question here is to ask, these clauses are asking countries to set their own limits for minimum wages. They are not asking for a general minimum wage, because that would be impossible to have. We have so many differences between developed and developing countries. So if you are a trading partner with the U.S., you are going to be requested to have your own setting on minimum wages. But this is not a fundamental labor right. This is so-called internationally recognized labor rights. And it comes from, it has its own history in the U.S. Development of GSP system. Of course, I agree with Guatemala representative Marco Molina in the sense that here the panel stated that it was impossible to set enforceability of labor rights in every place of work and with regard to every person in every time. That would be impossible. And I think that is a very important statement. And regarding the specific question of Mrs. Baratina about what laws haven't been challenged, I would refer to the case of European Union against being challenged by India about the question of putting some requirements to India and not to Pakistan, whether they were very much alike. That was one challenge, but in that case, India went along with this challenge. Another case, in some countries, you have forced labor legislation regarding trade, in the sense that you cannot be buying products made by forced labor. And I agree with that. The question was that is something that is not specifically put in the language of exceptions on WTO Article 20. So the question would be if a country would like to challenge that. No country has done that. But it's still there. And we can ask ourselves, why is that hasn't been challenged? And there is also a question of some countries putting in force the GSP systems unilaterally and apply with sanctions, sometimes trade sanctions. And nobody has challenged that neither. So there is some room to put these issues in WTO rules, but it hasn't had the experience until now in any case that I know. That I rest.
Thanks, Pablo. This time I think we'll go over to Doug if you wanted to take an opportunity to respond to any of those 6 questions you asked.
Well, I don't know that I necessarily have the expertise to answer those questions. I would just point out that even while we've been having this discussion, the top Democrats in Congress on trade issue have just put out a press release basically urging the Trump administration to take immediate strong action to end unfair foreign labor practices. So, it's just another example of the pressure that administrations are on to show progress on these issues by, in this case, probably seeking tougher labor provisions in NAFTA. I mean, it will be interesting to see what they do about that language that says that it has to have an effect on trade. Will they keep that, or will they try to remove it? And what would Mexico's response to that be? So anyway, I just thought it was interesting that as I was sitting here listening to the discussion, that this press release popped up in my email basket.
Great, thanks for bringing that to our attention. It's live from Washington, truly.
Yeah.
Colette, if you want to, optional.
I just have one brief comment on the question of comparative advantage and the race to the bottom. I think it's a very key issue, and there are no easy answers to this. But I would just venture to say that I think a lot of this needs to be looked at in a country and case-specific basis, because a lot of the investment, especially developing countries, attract because they have low wages, isn't always the type of investment that that country necessarily may want to have, right? It's usually the footloose type of investment that goes from country A to B to C, like garment industry types. So countries looking to develop sustainably, as Pablo was saying, I mean, you're not required to, hire your minimum wage for one, but also for two. Thinking about how to put in place certain labor laws won't necessarily, I think, first undermine competition, or second, get you to attract the type of investors that will ultimately help you to develop in the way that you're interested in. So, and again, this is very much, I think, industry specific, country specific, and comparative advantage specific, other than the ones because you're undercutting the wages. But so once we take the general debate and apply it, I think it will be a lot easier to figure out where the right balance lies between that, those two different factors. Thanks.
Great, thanks, Colette. And you, last word.
So on comparative advantage and the race to the bottom, a floor has been defined at the ILO, and I think it's in most FTAs. What I find striking is that in 1998, the Singapore Declaration and the ILO Declaration, they still had language, and I quote here, "The comparative advantage of any country should in no way be called into question." So basically saying developing countries should be able to use lower wages, lower labor standards to compete. But if you look at the 2008 ILO Declaration, it states very explicitly the violation of fundamental principles and rights at work cannot be invoked or otherwise used as a legitimate comparative advantage. So there is this floor. And that being said, I can't imagine that any developing country on purpose says, okay, let's violate fundamental labor rights here to better compete. What the US and what this case is about is not so much this floor internationally defined, but with reference to domestic law. And I think the idea was to interfere less with sovereignty that way, not to tell Guatemala what they should do, but rather to tell Guatemala, if you have enacted a labor law, however strict or loose it is, you should make sure it's effectively enforced. So it was meant to be less intrusive. Now, we spoke about other ways of doing this. One thing that I think requires further examination is, in the end of the day, and Doug was referring to it, that's what the Democrats keep referring to, we want to have free trade, fine, but it has to be fair. So we are willing to compete with imports, but they have to be made in accordance with minimum labor standards. So rather than going to these countries and try to get evidence and what have you, in California, for example, they have enacted legislation. For example, the California Transparency and Supply Chains Act, which requires any California company or anyone selling in California to disclose how they have their supply chain managed and what are they putting into place to avoid that labor violations come in there. So I think that's a promising way of doing it, to really put some pressure on companies. It's good business to comply with these labor standards and to involve consumer pressure here to ensure compliance with these standards. On the investment angle, you're right. So you were referring to the idea you cannot lower your labor laws to attract investment or trade. As I said, I doubted that countries do this on purpose, but there's a risk that if you increase them, you could be challenged by a company saying, look, we invested in your country assuming it wouldn't change. I think with current cases out of investor-state dispute settlement, I mean, you could try it, but I think it would be very difficult, especially if you bring it up to the international level to succeed there. Which also means on the online question, I don't think there's a challenge of incoherence here, that somehow if you've signed an FTA with the US and one with the EU, basically they require you to either comply with the ILO standards, that's the same, or to comply with your own law. As someone was saying, they will not impose EU or US standards on trading partners. Measures related to trade, yeah, that sounds a little more loose than in a manner affecting trade. And I like the question of what should this mean for NAFTA renegotiations. If you want to have more chances of success, try to get rid of the language in a manner affecting trade, or change it in some way, or clarify that what you mean with this is just affecting competitive opportunities, the way we have it in WTO law, not this more rigorous requirement of show me how much money you've saved by firing union workers and what effect that had on your exports to the US, which I think is pretty tough.
Great, thanks to all the panelists for those last reactions. We've now had you here for a little more than 2 hours. We have a few more minutes, but unless somebody actually is desperately dying to ask one more question or make one more comment, and there is, so let's take this one last, aware that you're standing between this group and the cocktail.
Thank you very much. I'm Wei Fo with the China mission to WTO. And I was compelling to ask the question because I think it's fundamentally important. I think here, what this case brings us is a question, really. And I think the question is, what is the aspect, or what is the appropriate aspect of a labor standard to be dealt with in an FTA agreement? Because I think, for me, I think there are 2 lines should be drawn appropriately when we're addressing this question. The first line is between upholding or advocating a social value vis-a-vis when enforcing the value. Because as we can see from the WTO agreement, there are a lot of values which are vitally important to all human beings, has been advocated and recognized, like the full employment, like the increase of real production and real demand, and the improvement of living standards. However, when we come to the enforcement or the obligations and the rights, we are very careful about what are the aspects of those rights, of those values to be enforced. So, in that sense, I think it's a bit. It's not surprising to me that the panel would held that actually though Guatemala government has been not enforcing its labor law in a consistent manner, in a constant and uniformed way, but it's not a violation to the FTA because it's not in a manner affecting trade. And I think this is one line, and the second line is to be drawn between within the FTA, which is the right to regulate and the right to fair trade. And I think a trade agreement is essentially, to strike a balance between these 2 essential elements. And the right to regulate, it relates to colleagues' comment on the concession of sovereignty. It's essential for the government because the value, which is the labor standard, is very, very important to Guatemala, to all the countries. And in a sense, if we give concession to the right to regulate, then there should be some limitations on that. So the other side is the right to trade, to fair trade. And I think that's why this FTA clause is written as not only just to enforce the labor standard, but also in a manner affecting trade. So I think, in a sense, it makes sense because you have to be affecting trade to get the labor standard enforced. So I think that's why also it relates to Pablo's comments on whether UN or ILO or WTO should be an appropriate forum to discuss such a matter. Thank you.
Great, thanks for that comment, and that it was useful to give you the floor for that last minute. Does any of the panelists want to just comment on that at all?
Just a small point, and it goes in the lines of what you were saying. I mean, they didn't even reach what I think is the most difficult interpretive question, because it then adds Guatemala could actually do some of these things if it can show it's a reasonable exercise of discretion or bona fide decision regarding allocation of resources. So there's this other very complicated requirement that in a way gives the right to regulate and the right to countries to decide where to put their resources first. So, and that's an exception that could justify labor violations, even those affecting trade. But how to read that one? Because there you go really at the heart of allocation of resources by governments. And this is not something invented by a tribunal, but written in the agreement. So that's probably for the next case, if ever one gets filed.
Just a quick comment on the last intervention regarding the multilateral answers, responses. Yes, we have, of course, a system in ILO when there is a complaint of unions of a party or a party in ILO. There are some kinds of control of standards. So Constitution in ILO allows Article 24 complaints, and the more serious are under Article 26 of the ILO Constitution, which is the most serious one, and is about the constitution of the Commission of Inquiry for the serious cases. And but I'm not sure that those systems are having a so positive answer to the question of whether to improve the labor laws enforcement in a country, whatever. So the question for me would be that the whole system of providing all the kind of responses is perhaps the most interesting one. The national responses, the national requirements for the unions to deal with tribunals and enforcement agencies is the first one, but you have as well the OECD guidelines, which in some cases have proven useful. You have as well the new UN principles and rights, UN guiding principles of John Ruggie functioning, and in many countries there are still some national plans to deal with that. And interestingly, they are ruling not only for their own companies in their own country, but also ruling for their own investment abroad. which is very interesting, because there, main countries, important countries, could rule for their own people, multinationals especially, how to act in foreign countries. Because there is a question for developing countries, for instance, to attract investment. They normally are offering some kind of facilities to invest in their own country. And that creates a difficulty for a developing country to attract investment if you are going to condition with some kind of ruling on social and environmental issues. So I think the holistic approach is the most interesting. And ideally, this would be kind of discussion between WTO and ILO, but the constituents of both have a different dynamic, and social ministries have sometimes different approaches from finance ministers, and there is a kind of political reality here that impedes to have an ideal response to your concern. Thank you.
Thank you, Pablo. Doug, just would you like an optional opportunity to comment? You're good? I think we lost. It's not
I'm here, but I don't think I really have anything to add at this point.
Okay, great, thanks. Oh, sorry. Our panel's done an admirable job in presenting the issues and presenting the number of different perspectives. This particular jury still seems to be out on whether or not litigation of trade obligations in a trade agreement is the best way to go in order to address concerns about unfair trade. So we can expect that these issues are raised in this dispute and raised today by this panel will continue to be discussed and hopefully learned from in order to continue to improve the framework for addressing social and economic issues, policy objectives and issues. So with that, we'll conclude the event, and on behalf of both the WTI advisors and ICTSD, I'd like to thank all of you, the participants, for joining us here today, and thank in particular all of the speakers, the panelists, the Permanent Mission of the United Kingdom for its support, the WTO Conference Service, and the ICTSD support team, and all of those who assisted in organizing the event. So if you join me in a round of applause for everybody listed. Before you go, I remind you again to fill out and leave the feedback forms, very valuable for the organizers, and please join us for a reception up in the gallery above the cafeteria, and we look forward to seeing you at the next event. Thank you.